The diagram that you see here, and I'm actually gesturing to empty space, as you can imagine, because it's a diagram that is appearing in this video. The diagram shows the several different pathways to the Supreme Court that policies can take. Note that the state courts are one avenue, and in fact, a lot of challenges to policy, to either protect or change them, move through state courts. A lot of very important precedents have the name of a state or the name of a state officer in its case. I'm going to talk in a future lecture about Mapp versus Ohio, an extremely important case that created the exclusionary rule, which still exists today, which is that evidence obtained in violation of the Constitution cannot be used in a criminal trial. Very important, and that represented a policy change. That represented a victory for certain interest groups that wanted the criminal justice system to work in a particular way, and it represented a loss for groups that wanted the criminal justice system to work in the way that it had been working, which is that whatever evidence, however obtained by the police, could be used in a criminal prosecution. So that came through the state courts. The structure of the state courts, I've kind of made it a small triangle and simplified it. State courts are actually quite diverse, as the states are themselves. The executive branch in states vary quite a bit. Most states have a multiple executive instead of a unitary executive. They don't just have a governor who appoints everybody else. Like the federal government has a unitary executive, there's the president who appoints everybody else. The states also have very diverse judicial systems. The way that certain kinds of cases are handled. Some states have drug courts that handle drug violations outside of the normal criminal justice system. Some states deal with drug violations within the criminal justice system. There are usually family courts, juvenile courts. Sometimes the family and juvenile courts are joined. There are all kinds of different, there's small claims court, there's property violations. The states themselves have a pretty big diversity, but in general, the structure of the state judicial branch follows the same rough outline as the structure of the federal judicial branch, which is at the bottom level, there are trial courts. At the next level, there are the first level of appeals courts, and then the top level is the state Supreme Court. So this triple layer of judicial analysis, we can put it, holds up for the most part across the entire judicial system in the United States. The first level is always some kind of trial or hearing. Now, it's not always the familiar trial that we see in trial movies where it's the defense and the prosecutor and the judge and the jury and a defendant and evidence in a particular crime. That is the model for criminal trials. Many trials or hearings have a similar type of nature to them, but many do not. So, for example, just even at the most basic level, at the bottom level, where at the federal level, I'll focus on the federal level because it's sort of the most general, it's the most important, and also state courts tend to follow the same basic architecture and spirit of the levels at the federal level. So rather than deal with all the diversity at the states, we'll just talk generally. District courts in the federal system are trial courts, and district court judges are trial judges. They preside over trials. Whether those trials are criminal trials where somebody is accused of violating the criminal code and there's a prosecutor and a defense attorney, or if it's a civil trial where two parties are involved in a dispute where there's the plaintiff who brings the dispute, who's saying you wronged me, and the defendant. Those are both trials with a judge that presides over the combat between those two sides. The notion of a combat is built into our judicial system. We fundamentally have an adversarial judicial system. The adversaries are the two different sides. It's essentially a joust of evidence and reasoning between two knights, and those knights are lawyers or teams of lawyers. The hearings that take place at the lower level, and in the diagram of the overall system, the other bodies that I have over here in this kind of trapezoidal shape, tax courts, military courts, administrative bodies like the National Labor Relations Board, the Federal Communications Commission. There are numerous administrative bodies in the executive branch that are called quasi-judicial, right? They basically perform a judicial function. They make a determination as to which party in the dispute is the winner and is correct and gets the outcome that they wanted, but they take place, they are run in the executive branch. So this sort of trapezoid over here, some of those are courts, but like military courts are actually part of the executive branch because they are part of the Department of Defense, which is in the executive branch. Tax courts are in the judicial branch, and most of the other things over here in this trapezoid are administrative bodies that are part of executive departments. So the one that I'm always most familiar with is the National Labor Relations Board, which handles disputes between employers and employees over various questions. That's an administrative body, but when you bring up a charge through the National Labor Relations Board, or bring up a complaint, I shouldn't say charge, a complaint, it's handled by that board very similarly to the way that a civil trial is handled, where there's a dispute, there's a plaintiff who says, I've been wrong, and there's a defendant who says, I didn't do anything wrong. So there are hearings, and then there are trials, and in all of these, there is an adversarial approach. Now, in some state courts, the adversarial approach is abandoned for more of a sort of fact-finding, what is typically called an inquisitorial approach. It's an inquisition, not like the Spanish Inquisition, but an inquisition as in it's a question-asking, fact-finding thing, not a fight between two sides. Typically, that model is only used in things like juvenile courts and family courts because there seemed to be a different need for a different kind of spirit rather than a combat. But for the most part, at the bottom level of our judicial system is some kind of two-sided combat. The prosecutor is the government representing the government, saying that the criminal code has been wronged, and in civil trials and in hearings, there's the plaintiff saying that I have been wronged through some kind of, there's a law that's been broken there, or not broken, but impugned. So in civil cases, the most common thing is a tort, which is a private wrong. This is where, somebody comes to your house and they slip on the ice on your porch that you didn't salt, and they break their neck and they sue you for negligence. That's a civil trial. The adversarial nature of the bottom level is essentially maintained through the three levels, but there's a difference. Only at the bottom level is the question a factual one. At the second two levels, the question becomes a question of law and process and interpretation. And I'll get somewhat into this in the second lecture in this three-part series in the judicial branch, but I just want to note that at the trial level or the hearing level, what is happening is the judge is presiding over a combat, and the jury or the board, if it's an administrative board, or sometimes if it's a bench trial, the judge, right? And this can happen. This happens very rarely in criminal trials, but it happens somewhat frequently in civil trials that are very complex, where both sides agree that the jury is not the best model for deciding who the winner here is. It's a bench trial where the judge is both referee and decider. In criminal trials, and anytime there's a jury, the judge may give the judge gives the sentence, but the judge doesn't give the verdict. The judge is essentially the referee, letting the two combatants, the two adversaries, fight it out for the votes of the jury. What's happening in this combat, however it's conducted, whether the final determination is made by a jury, by a judge through a bench trial, or by some kind of administrative body, the question is, which one of these two people has the facts on their side for their claim that's at dispute here? And the claim is going to be, in a criminal trial, this person broke this law. And the claim in a civil dispute is you did something that was wrong to me, and the applicable statute makes you responsible for it. So in a civil trial, the argument is about responsibility. In a criminal trial, the argument is about guilt versus innocence. In an administrative hearing, it can be a mixture. Is it guilt or is it responsibility? It depends on the nature of the hearing. But essentially, the question is a factual one. Is this group or party responsible, yes or no? Is this person or persons guilty or innocent? And the trial is much like a sporting event, it's a contest between two sides, and as I say, the judge is the referee to make sure that the rules are adhered to. Those rules come through two sources. Many of those rules come from the legislature. Criminal procedure is largely a result of statutory law. The Congress or the state legislature passes laws to say, here's how trials have to go, here's what motions look like, here are the rules of evidence, here are the rules of procedure, here are the steps. So the judicial branch has been structured. The reason why this structure exists is because not because the Constitution says so, but because the Constitution says there's going to be a Supreme Court and such inferior courts as Congress shall decide. So Congress created all of this structure. And Congress creates many of the rules. Now, many rules also come from judicial rulings, which we're going to talk about particularly in the next lecture. Those come down from on high. This is the Supreme, usually these rules will have been given by the Supreme Court, even though not all cases make it all the way up to the Supreme Court. Important rules of procedure have been handed down from the Supreme Court, where the court says, in addition to what the legislature says we have to do, the Constitution itself, or the statutes that Congress has passed, imply certain kinds of rights, responsibilities, procedures, mechanisms that get built into the trial. So a trial or a hearing is hemmed in by rules of procedure that come from one of two sources. That they come from the legislature or they come from the judiciary themselves. And the hearing is a combat that's defined by these rules of procedure, with the judge overseeing to make sure that the rules are obeyed. And then the outcome is decided on a factual basis by the jury, by the judge in the bench trial, by the hearing board, whoever it happens to be that the decider is. The jury is the most common, but by no means the only mechanism in our judicial system. Now, what the jury or the hearing board are saying is that factually, we think that you're guilty, or we think that you're innocent. Factually, we think that you're responsible, or that you're not responsible, that you have or haven't violated this particular statute of personal responsibility, or in the case of like the National Labor Relations Board, you have or haven't adhered to the requirements for collective bargaining or federal regulations on employee relations, whatever it happens to be. The standard of proof is high in the criminal trial. In the criminal trial, the prosecutor has to prove beyond a reasonable doubt that the person is guilty. In civil trials, the rule of evidence is that the preponderance of evidence falls on one side or the other. Civil trials don't require the plaintiff to prove beyond a reasonable doubt that the defendant is responsible. Only in a criminal trial. And the reason for this is that the idea is that in a criminal trial, the government has all the weapons and all the benefits, and so it has all the power essentially, and the defendant is, essentially outgunned. And so because the defendant is outgunned, the burden of proof, and it's a high burden beyond a reasonable doubt, falls on the government. In the case of private wrongs, or in the case of administrative struggles, the two sides are presumed, even if in reality it's not always the case, but the two sides are presumed to be roughly equal in power. And so the rule of evidence is that whichever side actually provides a better case, a better argument. So the same thing is going on, though. There's just a difference in the extremity of which side has to prove. In a civil trial, it's equal. In a criminal trial, the burden is on the prosecution. But no matter what the level of proof is, again, it's a factual determination. That's the last time that a factual determination is being used in our court system. And it's also the last time when it's just a single case. That's the other feature of the bottom level, is that it's all about cases, specific outcomes. I, Jack Miller, am charged with some violation of the criminal statute. It's about me. Am I guilty or am I innocent, given the evidence that the prosecution and the defense can bring to bear? And the jury decides whether I'm guilty or whether I'm innocent, and the judge makes sure that the trial has been conducted in a fair manner according to all the rules of procedure. Let's say that I'm found guilty. Now I can appeal, and as soon as I appeal, the question is no longer about truth or responsibility. It's about the law and the process. Our appeals process, when you go from the bottom level, where cases happen and they're tussling over facts and responsibility, and there's a decision made, at the middle and top levels, the question is not about, am I guilty or not? I can't appeal and say, no, the jury got it wrong, let's have another trial, right? What I can appeal is to say that the rules of procedure were incorrectly applied, the judge made a mistake, created a situation where it was unfair to me and my defense, and the trial has to be thrown out. Or I can be claiming that the law that I was prosecuted under, or the rules of evidence that were used to prosecute me successfully, are themselves inherently unconstitutional. Or that the statute which was used to prosecute me was incorrectly interpreted by the judge as he or she made the instructions to the jury, was incorrectly applied by the prosecutor, and that the statute was misapplied. Now, in all of those cases, there's now not a question about factuality. There's a question about the constitutionality of the procedures. There's a question about the constitutionality of the application of those procedures. This is now where we actually get policy implications, right? Obviously, I care about my trial and my outcome. I want to be set free. I don't want to go to jail. But at that level, I'm not really of interest to interest groups because I'm just a single individual. Once I appeal, if my appeal has policy implications to it, and not all appeals do, right? Some appeals are just like, the judge messed up. The rules of evidence were clear, and the prosecutor introduced evidence that the judge never should have let the jury see, and the judge screwed up, and so my trial should be considered null and void. Those questions get raised all the time in appeals. And so essentially many appeals are more or less about whether or not the judge messed up as referee or not. That's not of broad policy interest. It's stupendously important to me as the defendant, who might or might not go to jail based on this, but it's not of interest to interest groups. Interest groups are interested in cases with policy implications, and if the appeal raises a constitutional or statutory question that could change whether the law exists or not, whether a portion of the law has to be declared null and void, whether the law should be interpreted in a different way than it's currently being interpreted, those all have policy implications. That's why interest groups get involved in court cases. They get involved sometimes at the base level, but mostly they're interested in the appellate level, where the question rises, not every time, but in many cases, from a factual question of guilt or innocence, or responsibility or not responsibility, to a question of application of policy. So, for example, in the very famous Citizens United case, the original trial was about whether the FEC, the Federal Election Commission, correctly applied the statute, the Bipartisan Campaign Reform Act, to this particular, it was a documentary about Hillary Clinton that this group, Citizens United, produced and wanted to show. The FEC considered that documentary to be a piece of electioneering material as defined by the law, and applied the restrictions that the Bipartisan Campaign Reform Act applied to electioneering materials. One of the things that the Citizens United lawyers were arguing was that was a misapplication of the statute, that was a mistake, that a documentary is a piece of entertainment, not a piece of electioneering materials, and therefore the law doesn't apply. To that extent, it's not that interesting of a case. It has some policy implications, because if you're a documentary filmmaker, it means that this law doesn't apply to you if it gets ruled in that direction, and if it gets ruled in the direction that it is electioneering materials, then it does apply to you. So that has minimal policy implications. But the important question, and this was the other challenge that Citizens United group made, was that this law itself, which is being applied to our group and stopping us from showing our documentary, violates the First Amendment's protections for freedom of speech and freedom of association. That is where not just the Citizens United group that wants to show their Hillary documentary and documentary filmmakers care about it, it's where many interest groups care about whether or not this law takes a certain form of communication and restricts it or allows it to be unrestricted. This is a very typical type of case that has policy implications, and essentially, if you think that the Bipartisan Campaign Reform Act does a good thing, like your interest group supports that policy, then you want to protect the status quo. You want to protect the FEC's use of it. You want to protect its existence. You want to protect the restrictions that it imposes on groups involved in producing electioneering materials, whether they be television commercials, Facebook ads, documentaries that are shown in theaters. If you think that, if your interest group says, no, this restricts us and it goes against our interests, it prevents us from effectively advancing our interests by communicating, then you want that law or that provision in the law either struck down or you want it to be not applied to the kinds of activities that your group is engaging in. That will be the question that gets asked at the appellate level. Now, the only difference between the appellate level and the Supreme Court level is that the appellate courts at the federal level are made up of 3 judges drawn from a panel of judges randomly chosen. So if the panel of judges is 21 judges are available for a case, 3 of them are randomly picked, and majority rules. The 3 judges listen to the arguments of both lawyers, and now the judges are what we think of as the jury. They're the deciders. They're not referees anymore. At the appellate and Supreme Court level, judges are no longer the referee to make sure that the combat between the 2 sides goes well. They are the deciders. They also are the referees because somebody has to make sure that the lawyers arguing on both sides adhere to all the proper procedures and get their time and that motions can be heard and all that stuff. So the judges take on 2 roles now. They are the referees, but there's less refereeing really to do, and they're really the important deciders. Majority rules at the appellate level. If 2 judges say this is the winner and 1 judge says no, that's the winner, then the 2 side wins. The difference between the appellate level and the Supreme Court level is that the Supreme Court has 9 members. All 9 of those members take part in every case that they hear. So instead of taking a small section of the available justices, all of them take place. And it's still majority rules. It takes 5 votes to win. The other difference is that appellate courts can't reject an appeal. They have to take every appeal that comes to them. Whereas the Supreme Court, which gets thousands of appeal requests a year and can only handle somewhere between 50 and 100 cases, doesn't have to take up all of the appeals that are brought to it. It takes 4 justices. Note that that's just short of a majority. But these 4 justices aren't actually saying that we are going to overturn the ruling. They just say we want to have a hearing. And if 4 justices don't want to take up a hearing, or don't want to take up the appeal, then there's no 3rd layer. And what happens is that the ruling of the appellate court stands. And so the 2 or 3 judges who sided with the winner at the appellate level, they're the ones who have the final word on the case. So the Supreme Court either does or doesn't have the final word, but there is always the possibility for at least 1 level of appeal. But what the Supreme Court is doing is different than what the appellate court is, not different, it's similar to what the appellate court is doing, is they're asking the same constitutional statutory interpretation question. The question that gets raised at the appellate level, the 2nd level, is the same question that gets raised at the top and final level, the Supreme Court level. Is this constitutional? This law, is the application of it constitutional? Does it adhere to the language of the statute? Is it all done properly? Not the question, the factual question done at the bottom level, which is this person guilty or innocent? Is this group responsible or not responsible for violating this particular statute? That factual question just disappears. That's why there's not really a policy implication at the bottom level, and there is potentially at the appellate and the Supreme Court level. Now, the big difference between the Supreme Court and the appellate courts is this, is that appellate courts, and I'll talk about this in future lectures for sure, appellate courts are supposed to really just be applying Supreme Court precedent. They're looking at what the Supreme Court has said in the past about similar cases, and they're then making their ruling, their judgment as to which side actually has the better argument in light of precedent. The Supreme Court itself sets and develops precedent. Appellate courts can set precedents by saying, well, this is a situation that's never been seen before, not by the Supreme Court, not by anybody, and so we have to rule on it. We have to set the precedent. That's really a case where the Supreme Court is going to take that appeal because the Supreme Court doesn't want to leave precedent to be set at the appellate level. So while precedent can be set temporarily at the appellate level, it's really ultimately going to be set at the Supreme Court level. And so one thing that can happen too is the Supreme Court can say, well, precedent is, we're going to develop it a little bit, or we're going to overturn it. The appellate court might have gotten the correct ruling in terms of what the Supreme Court has said, and then the current Supreme Court might say, well, you got it right based on what we used to say, but we're saying a new thing. Or the Supreme Court can say, no, sorry, appellate court, we're not changing precedent, but you misapplied precedent. I'll talk a lot about precedent in the next two lectures, so I don't want to get too much farther down. But just want to note that then the Supreme Court is the final word. Now, it's the final word, except that the policy-making process is not a perfect line. It doesn't go legislature, executive, judiciary, end of line. It does go that way, except then there's a cycle that goes back. Whatever the Supreme Court rules, legislatures are then free to pass new laws that either restore some of the policy or change the policy or create something that's brand new that addresses the precedent that the Supreme Court has laid down. So there is an ongoing process. However, because of the difficulties of the legislative process, a victory in court, while not the final word, is a very enduring victory, right? It will take a long time for the legislature to enact something new. It will take even longer for a new series of judicial challenges to work through the courts and the court makeup in order to be able to essentially turn a defeat into a victory or a victory into defeat. Roe versus Wade is probably the best example of a long-term but not permanent precedent. The pro-life side lost in 1973 in Roe versus Wade and didn't give up. In several senses. One, they began lobbying legislatures to pass not abortion, outright abortion restrictions, which Roe versus Wade said are not allowed, but restrictions that fall short of outright illegal, making abortion illegal. And those cases then worked their way through the court and new precedents were added. And this is one of the things about the structure of the judicial branch is that it allows for this kind of iterative process. But also, the pro-life groups recognized that what they needed to do was transform the nature of the Supreme Court itself so that a future Supreme Court would overturn or erode Roe versus Wade to the point where abortion would be outlawable by state legislatures. So the Roe versus Wade was a victory, and it's been a very enduring victory. It's been nearly half a century now, but no victory is ever fully permanent. But 50 years is pretty permanent-ish. Okay, so this is, if I start talking about Roe versus Wade and the permanence of precedents and how precedents develop, that'll get me into the topic for the next lecture. So I'm just going to say that's the structure of the judicial branch, and the next lecture we'll look at how it is that judges and lawyers behave within that structure.